Good afternoon, and welcome to our monthly meeting of the Cobb County Board of Zoning Appeals. Before we begin, I would like to have us all stand, if we can, and pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Before we begin today, we have a new member, which I'd like to welcome. Alice Semmermauer is joining us from District 3. Welcome. Thank you. We'll now call our meeting to order. Please take a moment to silence your cell phones so that nothing interrupts us later. For those who do not have a copy of the agenda or who are attending for the first time, Mr. Peterson, do we have any consent cases today?
Yes, there are 7 cases on consent.
Okay, just wanted to double check. For those of you who do not have a copy of the agenda or who are attending for the first time, we will concern ourselves with cases that are on consent. These are cases that have been reviewed by the board and by the professionals from the various departments in the county, and to which there's no known opposition at the time. We have discussed these cases in our work session. Certain staff comments and stipulations have been made, and we do not anticipate any further discussion is needed for a decision. So, as we go forward, the County Zoning Division Manager, Mr. Peterson, will read each case into the record. Mr. Peterson will ask that you raise your hand as your case is called to signify that you are present. If you are here in opposition to a case that is currently on consent, Mr. Peterson will ask you to identify yourself as that case is read into the record. We'll then pull that case off of consent and hear it as part of our regular case agenda. We will then vote on all of the cases still on consent at one time. Once we've approved the cases on consent, we'll move to our regular case meeting. With that, I think we're ready to address the consent cases. Mr. Peterson, do you have any comments to make?
And before we begin, Madam Chair and Board, there is one case on today's agenda in which the applicant has requested the case be withdrawn without prejudice. That's variance case V7, Piedmont Urgent. The applicant did submit a request to withdraw this case without prejudice, and she is in attendance today.
Do we need to act on that now, Mr. Johnson? Yes. Do I hear a motion?
Yes, Madam Chair, and the applicant is present out there. You sure you want to do this? Okay, fine. I'll move. That was at the suggestion of the county attorney to make triple sure you wanted to do that, because we had a lot of complimentary things to say about you, so I just wanted to make sure that's what you wanted. Madam Chair, I move to that we allow the withdrawal of V7 without prejudice.
Second.
I have a second from Ms. Summer. All in favor, please place your vote. Thank you. It passes 4-0.
Okay, and with that, I'm ready to start the consent agenda. Cobb County Board of Zoning Appeals, variance hearing consent agenda for April 13th, 2022. First case on consent is variance case V25. Farhid Banay requests a variance to reduce the front setback from required 45 feet to 30 feet and reduce the major side setback from 25 feet to 20 feet in land lot 75 of the first district. The property is located on the southeast corner of Maple Brook and Dogwood Trail. The Board of Zoning Appeals recommends approval, subject to traffic comments. Is the applicant here for V25? Is there anyone here opposed to variance case V25? No. Let the record show there's no one opposed. Variance case V33, Jeffrey Williams requests a variance to allow a second electrical meter on a lot in a single-family residential district in land lot 336 of the 20th district. The property is located on the south side of Crew Lane, east of Trail Road. The Board of Zoning Appeals recommends approval, subject to no commercial or residential use of the accessory structure. Is the applicant present? Is there anyone here opposed to variance case V33? No. Let the record show there's no one opposed. Variance case V34, Johnny R. Mera requests a variance to increase the maximum number of children in a daycare from 14 per variance case V-124 of 2018 to 22 in land lots 1163 and 1206 of the 19th District. The property is located on the east side of Austell, Powder Springs Road, south of Oak Street. The Board of Zoning Appeals recommends approval, subject to the fire department comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V-34? No. Let the record show there's no one opposed. Variance case V-35, Aqua Design Pools and Spas LLC requests a variance to allow an accessory structure, which is a proposed pool and associated equipment to be located to the side of the principal building in land lot 560 of the 16th District. The property is located on the east side of Waldrop Road, north of Castlebrook Way. The Board of Zoning Appeals recommends approval. Is the applicant present? Let the record show the applicant's here. Is there anyone here opposed to variance case V-35? No. Let the record show there's no one opposed. Variance case V-36, Ballantree PMC Kyle Land LLC requests a variance to reduce the front setback from required 20 feet to 10 feet in land lot 139 of the 19th District. The property is located on the east side of Castle Haven Bend, southwest of Marley Lane. The Board of Zoning Appeals recommends approval, subject to the garage is to be located at least 21 feet from the back of the curb. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V-36? No. Let the record show there's no one opposed. Variance case V-37, Newton T. Nickel requests a variance to number 1, allow accessory structures, existing approximately 336 square foot garage and existing approximately 945 square foot building to be located to the side and in front of the principal building. Number 2, reduce the front setback for an accessory building under 650 square feet for an existing approximately 336 square foot garage from required 40 feet to 37 feet. And number 3, reduce the front setback for an accessory building over 650 square feet for an existing approximately 945 square foot building from required 100 feet to 75 feet in land lot 331 and 332 at the 20th District. The property is located on the north side of Dallas Highway across from West Santan Road. The Board of Zoning Appeals recommends approval, subject to the tree line between the house and the road be maintained. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V-37? No. Let the record show there's no one opposed. Variance case V-38, Joshua Glass requests a variance to number 1, allow accessory structures, which is a proposed pool and decking, an existing approximately 851 square foot garage to be to the side of the principal building. And number 2, reduce the setback for an accessory structure over 650 square feet for an existing approximately 851 square foot garage for required 100 feet to 12 feet adjacent to the western property line in land lot 153 of the 1st District. The property is located on the south side of Green River Court, east of Gramercy Drive. The Board of Zoning Appeals recommends approval. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V-38? No. Let the record show there's no one opposed. And that completes the consent agenda, Madam Chair and Board.
I had some stipulations I wanted to add to V-34.
Okay?
I move that to approve the following, with the following stipulations. Capacity will be approved based on overall approval by the State Licensing Board for daycares. Applicant is willing to add additional parking spaces due to increase in children if lack of adequate parking results in cars backing up on the road. An applicant will work with the various county departments to procure all necessary permits and approvals. So do I have a motion to accept those variants?
Your motion is for the consent agenda as read in?
Yes.
With the one additional stipulation?
Yes.
Okay. Madam Chair, I make that motion, although I would like an opportunity just to ask a couple questions before we vote on it.
Yeah, that's fine.
Okay, thank you.
Would you like the gentleman to come forward?
No. I can go ahead and ask my questions now. I just want to make sure on the folks who are here on the Ballantree case, if you could just nod your heads or something just to indicate, my understanding was that you'll have 21 feet of driveway between the curb and the front of the garage, so that's not going to impair your ability to build just because of the way the curvature works in the circle. That fantastic. And that was just being done to make sure that cars can park in the driveway without sticking out into the road. But thank you very much for that. And then the, Mr. Nichols, similarly, I wasn't able to get a hold of you. You able to maintain that tree line okay without that creating a problem?
Yes.
Okay, thank you. Okay, and then my other question is just to community development or to the county attorney. Is it okay to go ahead and, I don't know that I've had it happen before where somebody in my district didn't appear for getting their variance. Is it okay to go ahead and move forward with that if it's on consent and there's no one in opposition?
Yes, it is.
Okay, all right, so my motion remains the same. Thank you.
Okay. Are we good? Do you want me to restate? Alice, you-
I was going to second your
Okay.
motion.
Are we good? All right. All in favor? I'll vote, please. Thank you. All right. It carried 4-0. Okay, for those of you whose cases were on consent, you are free to go. If you do leave, I'll ask you, please do so quietly. So we're now ready to proceed to our regular case agenda. Our procedure here is that Mr. Peterson will read a case into the record. The applicant and/or his representatives of the applicant who wishes to speak will be asked to come forward to be sworn in. Likewise, anyone wishing to speak in opposition will be asked to come forward and be sworn in as well. The applicant and the opposition will have 10 minutes each to present their case. All testimony will be made from the podium to my right, where we have full AV capabilities. Okay, got that word. Testimony will be followed by questions from the board and may directed to either party. With that, Mr. Peterson, I think we're ready to start.
Okay. First case is variance case V23, Larry Manning. Request a variance to number one, reduce the rear setback for an accessory structure under 650 square feet for an existing approximately 550 square foot basketball concrete pad, required 30 feet to 9 feet. And number two, reduce the setbacks for an accessory structure over 650 square feet for a 660 square foot baseball cage, required 100 feet to 1 foot adjacent to the eastern property line and the 7 feet adjacent to the rear property line in land lot 975 of the 16th district. The property is located on the north side of Fairfield Drive, east of Fielding Way. The applicant's representative is present. Is there anyone here opposed to variance case V23? Yes, we have 5. 5, okay. Let the record show there are 5 people here opposed. Hold on. There are 5 people here opposed to variance case V23. All those in support, please stand up and raise your hands. Got 4. Let the record show there's 4 people here in support. All those folks wishing to address the board, please come forward to be sworn in.
Good afternoon. For the record, my name is Park Suff with the law firm of Sam's Locken and Huff, and I represent the Mannings in relation to this variance application that's before you. I'm going to speak for a little bit, and then I'm going to let Ms. Manning and Mr. Manning stand up and present to you, and then we've got some people in support that want to say some things too. I want to give you an aerial overview of the property. You can see the Manning properties in the center. They have a pool, they have a basketball court and a batting cage, and the Wismers are directly to in this direction to the north, if you will. And then to the south is the Shads. Both of them are in support. The Wismers are here personally to express their support for the application. I want to give you some context. As you can see, this is a new house in Indian Hills. And the house was built, and it has a terracing in the backyard. The road is low, it comes up high and then drops back down below. Ms. Ryan lives to the rear of the property, and she has expressed concerns in opposition to this, and I think she's here to express her concerns. This image also shows you the 20-foot drainage easement that runs along the rear of the property line. It's a drainage easement in the Indian Hills plat, and Mr. Boulogne, I know you understand what that means. It benefits the property owners to the either side of my client. It is for them, and Carl Carver can tell you that the drainage easement is not an issue in this case. We fully comply with the requirements and the use of that drainage easement and in no way interfere with it. In fact, Mr. Wismer is going to tell you that the drainage is much better than it has been. This is the basket or the batting cage, and you can see it sits significantly below the grade of the pool. One of the comments has been we don't have a hardship. In reality, if you look at the grades here, you can see the down low is the batting cage, up high is the pool. We do have steep topography. Having an area that is low actually is the best place to put this for visual for the neighbors. And you can see too, you have a fencing of the surrounding property and then the fence on the left-hand side of the pool. So if you're the neighbor to the rear, you're seeing a fence and then a fence up high, and actually the batting cage is lower than the high fence that blocks the pool. So visually, it's really no different than the fences that are enclosing the backyard and enclosing the pool. And actually the activity of the batting is actually farthest away from the residents, with batting in the direction towards the house. This is the basketball goal that is also in the backyard. Wanted to just point out, this is the code enforcement notes. I mean, you're dealing with an accessory structure, and if you can really clearly tell me what an accessory structure is, and you can define accessory structure and accessory use, this is the code enforcement notes that said the basketball court does not appear to violate setback. Batting cage violates the side setback, not the rear setback, but the side setback. This is what was communicated to my client when they came out there and looked at it. And again, this is because your code is quirky on trying to tell people what they can do in their backyard. And the neighbor has sent out letters to all the surrounding neighbors before my client even moved in, saying that she feels the batting cage's use would be quite noisy, disturbing, and unsightly. And I feel these sports facilities would be noisy, inappropriate for a neighborhood, and unsightly. I submit to you that suburban living is not quiet. If you think about your own existence, you know that there are, in the suburban settings, a lot of noises that are more annoying than kids playing. That's what we're talking about, kids playing. Barking dogs, leaf blowing, edging, mowing, Amazon deliveries, all this are things that are more annoying than that. The ECCA came out and said, we do not support this because there's no hardship. As I said, we've got a grade differential back there. They also said that they talked to the neighbor behind, but they didn't talk to the adjacent neighbors. They also noted in their comments that the Indian Hill Civic Association was not really opposed or supportive, but in fact, I've sent to you a letter today from the Civic Association fully in support of this variance. So we ask that you understand that their denial is also partly based upon that the opponent is a board member of ECCA. When that happened, they should have immediately not even participated. When their own board member is the opponent, they have a conflict. So I'm going to ask my client to come up here and go through who they are and what they want.
Good afternoon. On behalf of my husband, Larry Manning, and myself, I wanted to thank you for the opportunity to allow us to speak before you today. I want to start by telling you just a little bit about who we are. We are small business owners. Larry and I own 2 Primrose preschools. We've dedicated our professional and personal lives into providing safe, loving, and education-based childcare, to the 300-plus families we serve. As small business owners, we partner with experts in all areas of maintaining our buildings and campuses, to include contractors and city officials. We have continually reinvested in our schools and relied on the expertise of our partners in the expansions and improvements we have made. We are passionate not only in providing the best service for the communities we serve, but we also believe and have repeatedly demonstrated that we are responsible and reasonable neighbors with the commercial and residential owners around our schools. We are parents. We have 2 children. Nicole is 13, Matthew is 11. I'm sorry for my shaky voice. Nicole plays for Walton Metro Softball, and Matthew plays travel ball out of Eastside, Fullers Park. Both are aspiring to play high school and college, and if you ask our son, he's going pro. In February of 2021, we partnered with an experienced and well-known semi-custom contractor in the Indian Hills subdivision to build a home for our family. As parents, we are passionate about raising healthy and active children that will grow into good citizens and neighbors in our East Cobb community. We want our children off devices and outside in a safe environment to just enjoy being children. As with our schools, we partnered with experts to build our home and create an outdoor space in our backyard that would be not only safe for our children, but for our neighbors as well. Our intent for installing our batting cage was to protect our neighbors' property, and we relied on experts in the placement and installation of the batting cage. And like we have done in our 2 schools, we have improved land conditions to include watershed and drainage issues that benefited all of our adjacent neighbors. Finally, we are neighbors. We are responsible and reasonable, with a goal shared by our Indian Hills neighbors to raise our children and enjoy our community. We ask that the board assist us in maintaining the safe space we have created for our children and our neighbors, and we thank you so very much for your consideration and an equitable outcome.
I just have a few things to say, in particular about the cage and the court. Like we've been saying, we've relied on professionals. I'll remember sitting out there with the builder, him saying, you need to be 10 feet from the property line when putting this. I wanted the court to be 25 by 25. It's now 21 by 25 because we need to push it further away from that drainage easement. Apparently he was wrong too. And then the batting cage, professionals installed it. They know their business. I counted on them. You know, like she said, we are just looking for an equitable outcome. We have tried to communicate with Ms. Ryan many times. She will not talk. She will only text. She puts up a hand, says, you should have read the code, should have read the code. The problem I have with this is that and I'd like you to ask her why she didn't tell us about the code that she knew back in July and August. We had spoken about this, so she knew it was coming. And, you know, that's the way neighbors that I've always grown up handle things. They talk to each other. Anyway, if this cage has to come down, a bow net, I don't know if you're familiar with this, it's a portable net, will go up. The kids are going to practice their sports. As a kid, I put some balls through people's houses, glass windows. And my neighbors have young kids next to them. We want everyone to be safe. We don't want to do that situation, have that. Can I go to the next slide? I already talked about the court a little bit. We did put a net behind it that stands up to block the balls from going in the next door neighbor to Kelly's house, and I believe he's here also, the property manager. We're just trying to keep balls out, kids from climbing over fences. Like Park said, the president of the Indian Hills Civic Association is in favor of this. And I have hundreds of families in the East Cobb community that all play ball and support us. They obviously are irrelevant to be here. Otherwise, we would have brought in a whole bunch of East Side people. Next slide. So what we're asking is that I'd like you to ask Ms. Ryan if she's heard us in the last couple of months. We have used that cage a couple times, 2-3 times a week. I do not think that we have disturbed anybody, and we're talking daytime. We are asking for an approval with conditions if need be. We have been willing to talk about blocking trees, shrubs, hours of operation, what have you. And then just ask to have us work things out like civil people do. Next slide. This is just a letter from Mr. Shad, who's on the other side. I think you've seen that. And this is Mr. Wismer's letter, and he's here. And I want to say something about him first. He came here today. He's working over a Fulton Industrial Boulevard, left work. He's had a death in the family. A very good friend died this week. He's been to 3 wakes, and he came out here today to express his support, along with his wife, who just wants to be here to stand up. And I don't know if she'll say something either, but I just can't tell you how much I appreciate them coming. So
You only have about 40 seconds left.
And I will make it very quick and express our feelings as a family that lives next door to another loving family. We have children. Our kids are 6. We want to watch them grow up with their children. We live in this neighborhood, and we're going to live there until these boys go to college. That's why we chose to live there. It's a family-oriented neighborhood. Indian Hills is one of the best places you can raise a child. We waited for 2 years to find our home. Having these people move in next door has been nothing but a blessing to our family and where we wish to be in our society, with good people who have loved family.
They've been, excuse me. So I just want to say is that we have been very, very lucky to
Excuse me,
meet this
you're-
family.
you've run out of time.
They've been very, yep, make it real quick. They've been
I'm sorry.
coming to us, and we've been coming to them and resolving all our issues and communicating. So we really appreciate it.
Your time is up, ma'am.
Okay, thank you.
We're here to answer any questions. Thank you.
Anyone in opposition, please step up.
Madam Chairwoman, board members, my name is Richard Grome. I am president of East Cobb Civic Association and ECCA case manager for V23. This application for variance is a result of code enforcement complaint. There are several neighbors on 7 Springs Circle that object to this variance being granted. They are both present here today and have sent the Board of Zoning Appeals email letters of opposition. The applicant has built a 660 square foot batting cage as well as a 550 square foot basketball concrete pad with net backstop. Both structures are encroaching on the required 35-foot setback and partially over a 20-foot drainage easement at the rear of the property. The reason the applicant has given for requesting this variance is that the property is limited in size. He doesn't have enough land to do what he wants to do. ECCA has viewed the applicant's property and relevant rear setback and side setback from one of the adjacent neighbor's backyard. ECCA has talked with the applicant, 2 contiguous property owners to the rear of the property, another neighbor to the rear further down the street, and BZA member Kim Swanson while at the neighbor's property. There's no hardship present in this case with regard to shape or topography of the lot. The applicant's lot is a typical rectangular R20 lot of 21,086 square feet. By definition of R20 code, it is not a substandard lot. The applicant has graded the lot considerably, so the topography should not be an issue. He's the one that created the hill to put his house on. The basketball court and backstop net are built 25 feet into the required rear setback of 35 feet and over 10 feet over the drainage easement. The batting cage is over 650 square feet. By code requires a 100-foot setback. Even if it were reduced in size to below 650 square feet, it would not be in compliance with the 35-foot rear setback or the 10-foot side setback, and is built over 29 feet into the 35-foot rear setback, over 8 feet into the side setback, and over 13 feet over the drainage easement. Indian Hills Civic Association president has told ECCA that their board of directors does not have a problem with this variance request. However, their HOA rules read that they expect their members to abide by the Cobb County Code. Cobb County codes have been developed and codified for a reason and should be enforced. ECCA recommends that the applicant not be rewarded for disregarding the code at the expense of the tranquility of his neighbors. Mr. Huff has suggested that Kelly Ryan that ECCA should recuse itself from this because Kelly Ryan is a board member. Well, the president of Indian Hills HOA is also a board member, and he hasn't recused himself. There's no reason for us to recuse ourselves from this. Kelly, when we did take a vote on this, did recuse herself in the voting. Therefore, ECCA recommends denial of this variance due to the reasons given. Thank you.
Good afternoon. I've given pictures.
Please state your name.
Oh, I'm sorry. My name is Kelly Ryan, and I've lived at 1164 Seven Spring Circle for 24 years. And I do have pictures to send, to look at. My property is located behind 1090 Fairfield Drive. My neighbors and I oppose V23. Their names and addresses have been submitted. We all have written and submitted our opposition letters to the BCA. We request the denial for V23 for the following reasons. The owner, builder, and contractors ignored code requirements for accessory buildings and tried to bypass county code authorities. There should be consequences not enabling this egregious behavior, or it is left for the neighbors to police the situation and the BZA wasting time with violators. There is no hardship. This is self-created. The dirt on this property was moved for more than 10 days to form a hill on top of which the house was built and reinforced by 2 retaining walls. Due to the size and position of the house, the noise from the batting cage and basketball court funnel into our backyards. The pinging of baseballs off of bats, thumping of basketballs, and the light from the basketball court have already disturbed the tranquility of our backyards. And I do have an audio recording of that if you would like to hear that. The pole light from the basketball court shines into our adjacent properties. There is no need for these accessory structures. They're wants. They want a light, a 25 by 21 lighted cement basketball court and a 12 by 55 batting cage, larger than the size of a tractor trailer, which is 8.5 feet by 53. Both structures are encroaching on the required setback and the drainage easement and against code. We are concerned about flooding issues on our properties. In addition, we believe the noise and light has a detrimental effect on our property values and would deter future buyers and tenants. Number 3, the application, builder, and contractors ignored Cobb County building permit requirements stated in sentence 3 of their building permit. Quote, in being granted permission for this action, the applicant, owner, and/or agents are hereby notified of the requirement to comply with all ordinances now in effect with regard to Planning and Zoning Department's site plan review and inspections department. The builder, owners, and/or agents are required to comply with these regulations. They did not. Ignorance of any county code cannot be an excuse. It is imperative county codes are followed and rigorously enforced because of the high volume of tear down, rebuild construction in our county. There's a batting facility at 1666 Roswell Road, only a few miles away. On Fairfield Drive between Fairfield Trace, which is a cul-de-sac right across from their house, and Lower Roswell Road, 13 houses have basketball hoops in their driveways. The applicant can install a hoop over his garage, which is 73 feet from the street. A 3-way stop is in front of his house. In conclusion, V23 must be denied, or future applicants claiming ignorance of code or a self-created hardship will feel empowered to violate county code. The BZA should ensure zoning regulations are enforced regardless of property value or they become meaningless. Due to any of the above, but certainly in aggregate points, V23 should clearly be denied. Both accessory structures and pole light should be removed immediately. Thank you for your attention.
Hello, good day. My name is Ron Powell. I represent the property directly behind Mr. Manning. I'm employed by Minhoff Properties. In addition to this property, we own 25 residents in Cobb County and 3 commercial buildings. My first experience with Mr. Manning was back in August of last year regarding a chain link fence that went across the back of our property. He was requesting to remove it so that he could erect a different type of fence to more accommodate the aesthetics of his property. And I'm glad that he mentioned the drainage ditch, because my first experience with his contractor was to the fact that his contractor informed me out there at the location one day that he had authority to excavate 2 foot onto our property line. This was my first concern with the contractor, and I advised him that I wouldn't attempt that, because I was well advised as to what the codes called for. And since that time, we agreed to allow Mr. Manning to remove our fence on our property line with the understanding that he would have to conform to the flood codes and stormwater codes. His contractor rationale for this was to install a berm. His contractor had no intentions of contacting stormwater or flood for this drain on the back of the property until I brought it up to him and told him that the fence wouldn't be removed until he had went through the proper channels to assure that the floodwater wouldn't be coming across our property and Miss Ryan's. We also have a tenant located there, and just so you know, the basketball court is within 5 feet of our property line. The lighting on the basketball court is what I would consider a commercial luminous output. We manage 3 commercial buildings, and I don't even have commercial lights on my buildings that illuminate, such as this one does. I wrote a letter to the Cobb County variance. This has been
Madam Chair, time has expired.
a great disturbance to my tenant, her tranquility
me.
and peace.
Excuse me, sir, your time has expired, but thank you
Okay.
for your comments.
Okay, just say one more thing? Okay.
Ms. Swanson, since this is in your district, I'll let you take the lead.
I appreciate everyone coming here and discussing this variance. What I would like to have right now is our representative from Code Enforcement come to speak to the notices of violations you gave on this property. Could you come up, please? Hi, Brent. Can you talk about what accessory structures are and the baseball, what the notice of violation was and how they're violating according to the accessory structure?
Yeah. So my name is Brent Farrell. I'm with Cobb County Code Enforcement. We did receive a complaint on the property on November the 9th that the batting cage and the basketball court were being built and that they did not meet the setback requirements. Parks had mentioned that when we first went out, we said that their basketball court did not appear to be in violation, but that's because we had no access to the property because the homeowner wasn't there, so we could not access it in the backyard to measure it. But we did speak with the homeowner on November the 30th and got the measurements of the basketball court and confirmed at that time that it did not meet the setback requirements, so we issued a notice of violation for accessory structures for the basketball court and the batting cage not meeting the setback requirements. The ordinance defines a structure as anything that is constructed or erected, the use of which requires a location on the ground or attached to something having a location on the ground, including but not limited to tennis courts, fences, swimming pools, and buildings. And under the accessory building structures, uses, and decks under R20, basketball courts are included in accessory uses.
Okay. All right. Thank you very much for that. Appreciate it. Does anyone have a question with him?
Basketball courts are, but batting cages are not. Is there?
The batting cage would qualify under the definition of a structure in the ordinance.
Okay, thank you for clarification.
Do you have a question?
Yeah, Madam Chair. Sir, can I ask you another question? Thank you, Madam Chair. I thought the applicant said that, or referenced something saying basketball court does not appear to violate the setbacks?
Yeah, on our initial inspection, when we inspected the property, we were not able to make contact with anybody. So we couldn't, we can't go in the backyard, we can't trespass, so we couldn't measure the court at that time, so we weren't sure if it was in violation at that time.
And now?
Yeah, we have, a survey showing the measurements of it and everything, so it is in violation of the setbacks.
So we should disregard that comment?
Yes.
Thank you.
Okay, thank you. Does anyone else?
I'm good.
Just a few points that I have with regards to this is that when we sit up here as variance commissioners, we have this definition that we have to follow under the code, and it's a variance is a relief from zoning because of the shape, size, and topography of the property. And I know that Mr. Huff said that because of the topography, this is where this had to be placed. But the topography was created by the home being built up on the sides to accommodate the swimming pool. So that is something that wasn't inherent to the property. The property's square, the property was flat, and now there has been some work to bring it into where now you have less property on the sides and in the back because your pool is up high. The other point is that it clearly shows on the deed and the plat by the individual property owner that he held is that there is an easement. And in District 2, and all throughout other parts of Cobb County, but in District 2, we're having issues with drainage in a lot of the areas, in Indian Hills, in Atlanta Country Club, with a lot of these subdivisions that have had infill homes, and we just keep giving relief for setbacks and through variances, through setbacks and how they are built up. We're just, this District 2 has a lot of flooding issues. And in drainage easements, it's defined, when I looked up what a drainage easement was, which was clearly defined on this plat, the property owner is required to keep such easements free of obstructions and will maintain the easements in such a way as to assure free and maximum flow at all times. So I went out, given this easement issue in the back of the property, I went out and to see if there's ways that we can mitigate the fact that these two accessory structures are in the back of this property and that they are in violation of the setback. So I went out to see if we could put in trees along the back of the property. I can't put in trees because trees violate the easement. You are not required to put trees in easements because that's going to stop the flow of water. So then it was like, well, okay, can we mitigate it by putting a solid fencing along the back of the property? And I was told, no, that we cannot do that again. It violates having a structure in an easement. So then I looked at another way that we could mitigate the situation is possibly the owner of this property could put some trees possibly in the neighbor's property, which is in the back, to kind of buffer that. Well, in their property, they have a sewer easement, and we're not allowed to put anything in the sewer easements. So I have tried all different ways to look at what we could do to accommodate these structures, but I still fall back on the fact that when I'm to look at this variance, the requirements of a variance, it just doesn't meet. He has, the only thing that this property has is that it's too small for everything he wants. I know that Mr. Manning, when I met out there, he told me that he's built a number of daycare centers with playgrounds. And I felt that he really was understanding of what code was because of the things that he has built and the playgrounds that he's built. I think he's done an awesome job with mitigating some of the water flow off of his property, but again, we're in an easement. So I feel that with all of his builders, his the turf person, the fence installer, the company that poured the basketball court, all of them had a plat to show that's an easement. And they still put it in. And so now you come in front of the board to ask for forgiveness. There's just nothing here that supports this, with the relief from zoning. There's nothing that supports having these here. So,
If I can make a point of clarification and make a constitutional argument.
Excuse me.
You made legal arguments, and I'd like to challenge those legal arguments because you're.
Well, Parks, you do know that you're out of order, that you can't speak unless they address you and ask you a question at this point.
Okay, well, I would be glad to address the legal issue of the easement and the drainage easement and the legalities of that. As a lawyer, I would like to address that. And I offer the board for additional questions of that, and also offer the neighbor who is the beneficiary of the easement to explain to you the benefits.
I'm sorry.
Parks, please let the BZA member speak, please.
So, anyway, I am going back again to the fact that on this plat, there is an easement. It shows on the site plan that you submitted. It shows on the county plan that was submitted. This is an easement. In the back of the property where the opposition is, there is a sewer easement. And this is the definition of an easement. That it is to help with the flow of water off the property, and that nothing can be placed in that easement. And you have things in the easement. So with that.
I constitutionally object. That is not accurate statement of the law. You have Carl Carver here, who is stormwater management. You have your county attorney.
Excuse me, you're out of order.
You're out of order,
That
please
does not
stop.
mean that you cannot put anything in that easement. It's just factually and legally inaccurate. And I have to raise that objection as factually and legally inaccurate.
We just want to remind everyone here at the BZA hearing that you do not speak unless you're addressed by the BZA members, and you're out of order if you do so. Thank you.
With regards to an easement, Mr. Peterson, can you please tell me what is allowed in an easement?
For this particular easement, Commissioner Swanson, I would ask you to call Carl Carver up, our stormwater engineer, since this is a drainage easement, and he can
Okay.
address that question.
Carl Carver, Cobb County Stormwater.
So along the back of this property, there's a drainage easement. Can you tell me what is allowed in this drainage easement?
We typically don't allow any type of structure in a drainage easement.
So can we put trees in that easement to mitigate the sound and the visual of these accessory structures?
We generally don't like planted trees. If the trees were already there and they wasn't taken out during a mass grading operation or something like that, then we don't go in and take out trees. There's a lot of times easements are created in subdivisions that are going through drainage swells where there's existing trees. We don't require them to take those trees out. We just don't require them to plant trees in the easement.
Okay, thank you. Do you have a question, Tim?
What, if any, improvements were done to mitigate or improve the watershed and drainage on that property?
The applicant has a very extensive artificial turf throughout the whole backyard with a very sufficient gravel bed that's more than mitigating what would be required. His total impervious coverage is probably somewhere around 28%. He's allowed up to about 35%.
And isn't that concrete pad for the basketball court? I mean, it's an impervious surface, so.
Yes, it's in the middle, or it's within the backyard, and it completely drains into the artificial turf, which is mitigated. In addition to the mitigated artificial turf, from my site visit, he has French drains crossing the backyard as well.
Thank you, Madam Chair. Do you have any opinion on whether the improvements in the aggregate hinder, aid, or have some impact on the extent and the ability of water to flow across what had been an easement area?
When I was there, I didn't see that the upstream drainage area would have any problem going through. It was the people to the left of his site would benefit from that drainage easement. And it didn't seem to block or hinder that drainage from coming through there.
Okay, thank you.
So again, getting back to the drainage easement, we have an easement, we have accessory structures in this easement. And while he's done a great job of mitigating the flow of water across his property, these two things are in the easement, as well as we can get out of the easement issue and they're in the setbacks. So if these items can be moved closer to the house, which because of the pool that was installed, there's no way from code enforcement to move it off of the setbacks. And there's still the issue that I cannot put to help mitigate the situation. We cannot put trees, we cannot put fences, we cannot put anything to help mitigate this to neighbors that are impacted. So, Mr. Huff, would you please sit down? So I would like to make a motion that I deny this variance, and that you have 30 days in which to remove the batting cage because it's easily removable, and 60 days to remove the basketball court. That's my motion.
Do I have a second?
Well, I'll give a second for purposes of discussion, and if I could state an alternative. If the picture could be put back up, that was just up a second ago. It's there. The other one showing the.
I think my first line is probably.
Okay. And I've come to realize today what a nuisance I probably was growing up in my neighborhood, dribbling my basketball up and down the street. But it appears to me that the neighbors on either side have no problems. The objection comes from the neighbor to the rear. And I do understand that both a batting cage and a lighted basketball court can create both visual and noise problems, and I appreciate those. My preference would have been that we had done something to move the batting cage forward, require landscaping, that I wish these parties had engaged in a serious discussion about that before coming here today. That as far as the basketball goal goes, It looks like, as best I can tell from this photograph, that what we probably have here is a perforated, rubberized surface over concrete, but I'm just guessing, which poses a certain risk when you try to move laterally. You have to watch out, you have to pick your feet up. But given the fact that the neighbor to the left has no objection, my preference would have been that this thing be moved closer to his property line, and they could maybe even retain some of the same surface. I can't tell the elevations precisely from here, but it looks terraced. But it could probably come 5 feet closer to that neighbor there, and probably 5 feet further away from the back line, and that a very comprehensive landscape buffer and either higher fencing could be required. And in that regard, what I note is that I have a son who actually owns a townhome that backs up to an interstate highway, 395 in Northern Virginia, in Alexandria. And because of the sound baffling and sound fencing that's there, that you can sit on the back deck and it's nice and quiet. So I wish those discussions had occurred prior to now. I do understand why a neighbor would be perturbed at the volume of noise that would have come from all this, but it's kind of unfortunate that whoever designed all this didn't take those things into consideration on the front end. Leaves me in a complicated place. If the vote is that it has to come down, I'll at least offer to come help you put a new basketball goal up if you like. I know how to do that.
For your comments, I looked at trying to help to mitigate this. I looked at trying to help to put some sort of trees, shrubbery, a different type of fencing system, which none of them are allowed in this easement. So, and then I tried to look at seeing what we can do in the back. That doesn't allow anything because there's an easement back there. So when you look at how to, so these two neighbors on either side are fine, but he has neighbors in the back as well. It's just they're not part of their subdivision, but they're still neighbors. And while I don't, again, you know, my son was a baseball player. I was a basketball player. I would have loved to have all this in my backyard, but I couldn't because I don't meet the setbacks. So here's somebody that comes in, they put this in, hoping, and then come in front of the variance and say, oops, this is in a setback issue, and code enforcement had to come out. But my biggest with all variances is how can we mitigate this so that the neighbors, all the neighbors are not impacted, and those would be those in the back. But I'm not allowed to do that. So I can't, there's nothing, sir, both of you sit down because I'm not asking you of any questions. This is like my time to speak, so please sit down. If you have an issue, if you haven't, no, please sit down. You've already had your
Madam Chair,
date.
could we just take a minute and let everyone de-escalate for a second?
Yes.
Please?
Take a brief break.
Just 1 minute break, let everyone de-escalate. Let's remind that we have decorum, we have order. You do not approach the dais unless you're asked. That is our rules. Thank you.
And so he has all this great stuff, and it's
Madam Chair, whenever y'all are ready. Yes, Jim.
Brent, if I could ask you a couple of questions. In regards to the, okay. Hi. In regards to the lighting, the pictures that we saw, is there code regarding what's allowed and?
There's no code for residential lighting.
Okay. That looked to me to be an issue that should be addressed, because if I was the backyard neighbor, that would be a problem for me. So there's no code regarding that.
Yeah, not for residential properties, no. Only for like amenity centers and neighborhoods, they require lighting plans, but not for houses.
Okay. So I'd like to change my motion, withdraw my motion. I'd like to withdraw my motion and put forth another motion since it wasn't seconded. Is that okay?
I believe Mr. Bloin seconded for purposes of discussion, so
For discussion?
I'll be happy to either withdraw my second or allow her to amend her motion, whichever you prefer.
At this point,
Although
let's-
a new motion would supersede anyway, correct?
correct.
Okay.
So I'd like to make a new motion that we put this on a 30-day hold for the next meeting. And during that time, I would like the applicant to look at a way to move his basketball court closer to possibly the Shad's property, and closer to the house and away from the back of the property. And possibly moving the batting cage, again, closer to the property of the house, closer to the house, along the other side of the house. And it can't get any closer because it's right on the property line to the neighbors. So my motion is to hold it for 30 days and to come back with seeing what their plan will be to bring both of those structures closer to their home, and we'll go from there. That's my motion.
I'd second that. And if I could just add a comment to the, thank you, Madam Chair. My comment would just simply be that, that while the applicant seems like in so many respects, the great folks, that they also have to carry the burden of being a good neighbor to the folks to the rear. And the burden's on them to come up with, in my opinion, to come up with a plan that attenuates light, sound, any adverse conditions created by any of these items, which they may ultimately be allowed or not by the by this group.
So you've made a second?
Yes.
Okay. Please vote. Motion passes to hold for 30 days. Motion passes to hold for 30 days.
Okay, next case is variance case V30, Jennifer Wolf for Take 5. Request a variance to number 1, reduce the setback for a freestanding sign from the center line of an arterial road right-of-way from required 62 feet to 50 feet. And number 2, increase the maximum total sign area allowed per sign from required 49 square feet to 73.5 square feet in land lot 924, the 17th district. The property is located on the east side of Accessory Road, north of Terrell Mill Road. The applicant is present. Is there anyone here opposed to variance case V30? Let the record says no one opposed.
Sorry, good afternoon, board members. Good to see you again.
Yes, good to see you as well.
Cobb County staff, good to see you as well. Thank you for allowing me to present today. My case will be brief. I did a video to kind of explain what we're here for. It happens to relate to signage again. We're requesting a reduction in setbacks due to placement for practicality, due to neighboring tenant signage, and best visibility. The reduction would be a 12-foot setback from the required 62 feet by code to a 50-foot setback to allow the sign to be placed in the center of the lot.
She does have this question.
Thank you. I do have still photos for any board member that would like to see still photos of the place versus the video. On this lot, there is, the left side of the property has a median that would allow for a sign to be placed. However, a directional sign indicating to exit the property would be located behind the existing stop sign. So there's a little bit of signage clutter, but also it lacks visibility to see the business until you're right up on it. So we feel that the placement that's being proposed would be the best opportunity to market by utilizing the ground sign allowance by Cobb County Code. Thank you.
Thank you. Thank you. So I went by and I looked at this, this new store, and it has all the signage on it like you see, and I don't see that there is a hardship of where to place the monument sign. And so I do not have any issue with the location of the monument sign But I do have, on number 2, you wanted to increase the maximum total sign allowed. I think that the color and the visibility of your store is you can see it from all directions when you're going up and down the road. You can see it. With the monument sign out here, you'll even be able to see it. It'll be even more visible as to, like, here is where this store is located. So I think that as far as like the hardship that there would be no visibility, I think you have great visibility. The building has quite a number of signs around it. Looks great. It's cleaned up the area a lot. I commend you for that. And there is a hardship of where to place your monument sign, but there's no hardship, I believe, for your request to increase the maximum total sign allowed from the 49 square feet to 73.5 square feet. So I would like to make a motion that we approve V30, number 1, to reduce the setback for a freestanding sign from the center line of an arterial road, right away from required 62 feet to 50 feet, and deny number 2, which is to increase the maximum total sign area allowed per sign from the 49 square feet to 73.5 square feet.
Second.
Seconded by, are there any questions? Are you ready to vote? Please vote.
Thank you, board members.
Thank you.
Okay, next variance is variance case V31, Seaman Network, Inc., Five Below. Request a variance to increase the maximum allowable sign area for a wall sign on a building over 2 stories or 20 feet in height from required 200 square feet to 330 square feet in land lot 36, 37, and 1296 of the 17th and 19th districts. The property is located on the south side of Veterans Memorial Highway and on the east side of Whispering Pines Road and on the west side of Mapleton Parkway. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V31? Let the record show there's one person opposed. All those wishing to address the board, please come forward to be sworn in.
Good afternoon. Thank you for hearing our case. We presented a quick presentation to show what we are asking for. The Five Below is going into the village of Mapleton, which I believe used to be a Kmart building that is now being split between multiple anchor tenants. Five Below is proposed to be on the end cap space. The existing code allows for 200 square feet of signage. We are seeking a variance for 330 square feet. The Five Below blue is counting towards the blue background behind the signage is counting towards that square footage. The channel letters by themselves are 159.9 square feet. So it's really just seeking for that additional blue branding behind their white letters. Here we're showing what the store proposed would look like. And here we just wanted to show a quick market map of the other Five Belows in this area and just kind of quickly show that the blue branding behind their signage really helps with their brand recognition to make the letters pop. We are respectfully asking the board to consider our request for relief from the code due to 3 reasons: the economic viability of the business, the visibility of traffic flow, and 3 being that there is no on-street signage presence that would identify the Five Below tenant space. High level, the wage on e-commerce versus brick and mortar stores. It's critical for Five Below and their stakeholders to have the site branding recognition for their space. They're relatively new to the market and they're establishing brand recognition, and it's highly significant to the success of their business. Five Below also signs 10-year leases at a time, so the space, their presence wouldn't be going anywhere in the near future. So it's pretty important to them to have the branding on their buildings to be successful in those spaces. Another thing we wanted to touch base was the setback of the shopping center is approximately 400 square feet from Veterans Memorial Highway, and that there are other businesses and parcel spaces in front that obscure visibility. And again, there is no on-street signage that safely identifies Five Below as in the center. We have showing the westbound approach, which shows there are buildings in front of the actual shopping center. So there's not a lot of on-street visibility. Here is the eastbound approach. We have the Papa John's and the Sherwin-Williams buildings with multiple trees around it that also obscure visibility. And there is the eastbound with the multi-tenants pylon as an example. There's no space for Five Below to go onto that pylon. We did receive, just quickly, we received approval from the Mableton Improvement Coalition with 2 conditions, which both were approved by the landlord Brixmore. And then we just have some survey statistics that we wanted to show and the safeties of navigating within shopping centers. And that is the end of our slide.
Madam Chair, can you ask to have her name for the record, please?
I didn't hear you state your name and company.
Oh, Lindsay Lupino from Easement Network.
Thank you. Thank you, Brian.
Good afternoon. My name is Robin Meyer, and I'm with the Mableton Improvement Coalition. Ms. Lupino is exactly correct. We are very excited that we're going to see some new tenants and some upgrades to the shopping center, and we are in full agreement with the variance that they have requested as far as the size of the sign is concerned. The points she laid out are exactly what I would have said if they weren't already so perfectly spoken. But we would be remiss if we did not take this opportunity to address 2 other problems at the center that you saw in our letter. I spoke with Daniel Bush at Brixmore, and he was also, as Ms. Lupino stated, in agreement with the conditions that we have asked for. The prohibition of vehicle parking, except by use of tenants and customers, and the installation of 4 stop signs at the intersection within the shopping center, where right now it's just painted on the pavement, somewhat faded, and if you're the second car in line, the first car in line is already parked on top of that instruction to stop. So we appreciate the agreement to that request. We would like, however, to modify it slightly. We understand that the tenant in the shopping center that has brought to our attention the problem with vehicle parking, i.e. Amazon, is actually a tenant in the shopping center. They have some office or administrative space there. So in addition to the prohibition for vehicle parking that we have laid out in our letter, we would also like tenants in the shopping center to be limited to 12 vehicles with company ID, no more than 12 vehicles with company ID can be parked in front of the shopping center. Behind the shopping center, there's more space, they could certainly be parked there. But we, and I feel sure the new tenants and the owners and managers of the shopping center are happy. We want to move away from the look that this is a vacant piece of property available for parking by Amazon trucks or anybody else who might be the Amazon truck parking problem 10 years from now. You know, we fully understand that these new tenants are coming, they'll be needing these parking spaces, and the Amazon trucks may not be a problem today. But 10 years ago, we never expected the shopping center to be vacant. 10 years from now, who the heck knows what might happen. So we very much ask that you include those two conditions in your approval. And as you're thinking about that, I'm sure you're thinking, well, this is not about the sign. Well, you're right. It's not about the sign. But it's about the property. It's the property that's here before you today, not the sign company. And your decisions run with this land. They do not run with the applicant. So while we have this opportunity, let's make an improvement for the community in this pivotal piece of property. This is the busiest intersection in all of Mapleton. So we look forward to having it look better in 12 months' time than it does today. So thank you very much.
Ms. Myers, could you have one question? Would you please just restate those two conditions so we have clarity since it's modified from the original letter? Thank you.
Yes. The easy one is installation of 4 stop signs at the intersection within the shopping center, as noted on the diagram that was in my comment letter and is shown on the screen. And a prohibition of vehicle parking for commercial use except for tenants and customers of the commercial tenants in the center. And additionally, tenants be limited to 12 vehicles with company ID parked in front of the building.
May I ask a question? Have you checked with the leasing agent to determine what's in the agreement with Amazon regarding vehicle parking and use of the parking lot?
When I spoke with Mr. Bush, he told me, I have no firsthand knowledge of this since I just live in the community. I'm certainly not involved in this business. He told me that Amazon was on a 30-day, how did he put it? 30-day notice. And he expected them to be leaving before the new tenants moved in.
So there was nothing in the agreement with Amazon regarding number of vehicles allowed or not allowed?
I have no idea. I have no idea. I wouldn't be privy to that.
I think in the general commercial, that's not referenced. Is that correct, Mr. Peterson? The number of vehicles related to tenant is not referenced? Oops.
Can you repeat that?
Okay. In the particular zoning, is there any place in that zoning code that limits the number of vehicles a tenant may have on the property?
No.
Thank you. Did you?
Hello, everyone. My name is Felicia Johnson. I do work with Altair Sign and Light. We are the contractor for this Five Below for the install that we are proposing and requesting. She's basically said everything that is true and factual. The one thing that I will reiterate is that we've done a number of different variances in Cobb County, the Honey Baked Hams, your Lidl stores, and it has been based upon the size of the sign and the distance from the front of the property or the road front, which has been an advantage to be able to see that from that far of a distance where you have other buildings in front of the property. Also, one of the things that we tend to forget about is that we have all ages that are driving, and we all don't have that peripheral vision and able to see all things at one time. So Even my mom is 79 and she's still driving. And so we have to be considerate of those and all people that are driving when they are approaching a establishment and being able to see the signage for a particular business.
Okay. Thank you, ma'am.
Thank you.
Do we have any questions? Then I would like, hopefully get it here. I would like to make a motion that we accept the variance requested with the two stipulations of the installation of the 4 stop signs at the intersection within the shopping center and prohibit commercial vehicles parking there except the tenants and their customers. And in commercial, and as it relates to commercial vehicles, limit it to 12 branded vehicles per tenant parked in the lot.
Madam Chair, before we get a second, just to rephrase that we're approving the application, not accepting the application. A motion to approve is what we need, not a motion to accept.
Okay. Can I restate that for you folks? A motion to approve? Thank you.
I just have a clarification, was prohibiting no more than, or limited to only no more than 12 in the front?
In the front.
In the front, but then they said it would be okay that the remainder be in the back of the lot. So could you add that? Because I think you just said.
Parking in the front.
For the tenants, no more
For
than 12.
the tenants, more than 12 branded vehicles parked in the front of the retail space. Remaining vehicles could be parked in parking located behind. Do I need to restate that? Please tell me no. All right. Do I have a motion?
You made it, Madam Chair, but
Second.
the second would simply be, I'll give the second, but let me also just provide a question as to whether you're comfortable with the motion. It would just simply be as to the fact, being a 5 below, they would have delivery trucks coming as well, and just making sure that prohibition wouldn't adversely impact those delivery trucks in any way. But yeah, other than that, I second the motion.
Okay. Are we ready to vote? Any more questions? All right, please vote. Thank you. All right, next case. Michael Bruce.
Okay, variance case V32, Michael Bruce requests a variance to reduce the rear setback from required 35 feet to 30 feet in land lot 163 of the First District. The property is located at the western terminus of Huntingford Terrace, west of Huntingford Drive. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to the variance case of V32?
Yes, one.
Let the record show there's one person opposed. All those wishing to address the board, please come forward to be sworn in.
Good afternoon. Please state your name.
My name's Shane Bruce.
Go ahead.
Well, thank you for being here. I've got a new appreciation for what you do, so thank you for that. My name's Shane Bruce. I'm new to the area. My family and I, 5 children, moved to this location almost 2 years ago. We love the area, had a difficult time finding a home. You wouldn't believe how difficult it is to find a home at reasonably priced in this area these days, but we did. We found an older home, 0.6 acres with a pool, everything that we're looking for. We had some issues though. The lot that you see today is new and it did not look like that previously. A large portion of my lot is unusable, and what I mean by that is two issues. One is the shape and grade of the yard. If you take a line and draw it to the bottom part of that pool deck what happens with the yard is there's a significant downgrade or gradation leading to a drainage ditch that has water runoff from both the cul-de-sac and from neighboring houses. The second issue that I had in the past was that the yard was significantly overgrown. We had a lot of very unhealthy trees and some of this Georgia English ivy, which I only have recently figured out what that is. But so we cleared all of that, created enough usable space, and then we wanted to put in or extend an existing deck a little bit and add a covered roof. So we found a friend who knew a friend who was a contractor. We started to design that. And we left it to them to handle all the things that were required until an inspector with the home, with Cobb County showed up, and we got a quick TED Talk on county zoning and setback requirements, of which we had violated. And so we worked for the past few months to, do all the things that we have to do to prepare for the variance, including the plot map. It turns out that the inspector was correct and that we are just about almost 3 feet too close to the rear setback that should be 35 feet. And so, first off, I'm embarrassed that we're here. I wish we would have been more informed. We had an obligation to do so. However, I would ask that the committee approve the variance based on a couple of reasons. One is that we do have a hardship. Although 0.6 acres is quite a large lot in this particular neighborhood, the use of a large part of that because of the grade is unusable. And so by what we did by extending that deck and picking that particular location is that we took advantage of unusable space. The patio sits up on stilts. You can kind of walk under the back corner, providing more flat area for that building. It's built enough for my family to be able to enjoy. It's about 20 by 20 feet. It does have a cover. Also, it is a minimal infringement on the setback, 3 feet. I wish it were 0, but it's a lot. It could be a lot worse. Also, the landscaping and terrain. I brought some pictures, but it sounds like your camera is out. But I took a picture standing on the back corner, and Ms. Swanson could attest to this. The corner that violates the setback, a picture towards my rear neighbor. In addition to that 31 feet that still exists, there's another 20 plus feet of landscape barrier where there's lots of trees and natural area. And then there's a sharp decline, and my neighbor's house sits much lower in that space. All that to say, you can barely see my building, even though it is raised up because of the landscape and the location of the houses behind. And by the way, all of those neighbors have agreed and have no issue. And so what you'll hear from the ECCA is a denial, a disapproval, whatever the right word is. But I will note that it's somewhat of a lackluster decline. I mean, I've been working with Christy for a long time. We have had a lot of conversations. Her and I think the rest, the president of the board, if I'm misstating that, I'm sure she'll correct me, but we're in agreement with the variance. And then I guess during a public hearing, an anonymous person or persons, based on the fact that I have already built the building, not on the merits of the variance itself, wish to decline it, which has kind of led to their position. Thank you very much.
Thank you. Anybody have any questions of him at this point? Okay, yeah. You can be seated.
Good afternoon. My name is Chris Lindstrom, representing the East Cobb Civic Association.
Could you speak up a little bit, please?
Yes, is that better?
Yeah.
Yeah. My name is Chris Lindstrom, and I represent the East Cobb Civic Association and case manager for V32. While Willow Creek Point HOA does not have an issue with the application for the variance, ECCA is aware of one neighbor who may be in opposition. We don't feel that there was a hardship. There is no hardship. The covered decking is already built, which makes the applicant's statement for requesting the variance incorrect as written. ECCA board and members reviewed this variance, and while we believe the owner is new to the area and trusted the builder, this structure was completed prior to applying for the variance. ECCA recommends denial of this variance as there is no hardship. That's it. Thank you.
Thank you. Anybody have any questions? Kim, it's yours.
I did go out to see this property, and under the requirement of variance, the size, shape, and topography, and I think this pretty much fits the bill that there is a, the size is rather big for a subdivision. The topography, there is a definite slope that goes down towards back towards the triangle, what he's pointed to now. The neighbors behind sit low, and even if he was within the setbacks, you would still see part of the roof. So whether he's like 5 feet over the setback, it has no impact to these people here, and none of them, I didn't receive any opposition from any of those neighbors. In fact, I didn't receive any opposition from any of the neighbors on all sides of this property, which I think is really important, that they're fine with it. I know he's very apologetic of the fact that when I called him, he was like, oh, I have to tell you that it's actually built. And that again, you know, it's contractors that come out and they don't comply with the code. And so it's very well done, and it does provide them space because again, they have this very large property, but very little flat space. So this deck kind of cantilevers out over to give them at least a little bit more space on the side. They have a large family, and I think that I support the fact that, and I understand East Cobb Civic Association wanting to stick to the size, shape, and topography, but I don't think they really looked at that there is a problem here with the size, shape, and topography. So with that, I would like to make a motion that we approve V32 and that we reduce the rear setback from the required 35 feet to 30 for his covered deck.
Second.
We have a second from Ms. Summer. Are you ready to vote? Okay, please place your vote. The vote passes 4-0. Thank you very much. Ms. Swanson, I think you wanted to make a comment?
Yes, Mr. Peterson, I just want to make a comment on the zoning that came in on consent, V25. The applicant was here. They were in the parking lot, and so she had texted me during the zoning saying, was it approved? When can I leave? So they're here for a long time, but they were in the parking lot.
There may have been some confusing because when these were submitted, we were still
Right.
Changed last month, so.
And I had explained that to them when I first met, when we still were in those COVID rules. And so when I told her that it was on consent, I forgot to tell her that you can now come in. So she was here.
All righty. We completed all of our cases, Mr. Peterson. All right, we need to handle housekeeping. Ladies and gentlemen, have you read the minutes from the meeting on March 9th as well as April 11th? And do you have any comments or corrections? So do I hear a motion to approve the minutes?
I make a motion that we approve the minutes
Do I have a
from
s-
March 9th and April 11th.
Do I have a second? Please vote.
Second.
Alice? All righty, thank you very much. Is there anything else that needs to be mentioned before we adjourn this meeting? Okay, do I have a motion for adjournment? Do I have a second?
Second.
All right, all in favor? Say aye. All right, thank you very much.